2015 started on a not too pleasant note for the judiciary. Like it happened in 2014, judicial staff workers again downed tools and embarked on an industrial action to force the executive to implement a verdict of the Federal High Court Abuja, which declared as illegal, unconstitutional, null and void the control and disbursement of funds earmarked for the judiciary by the executive arm of government. After the intervention of some critical stakeholders, the workers resumed, and perhaps the first challenge the courts were confronted with were the pre-election matters, which could have affected the conduct of the general elections. After the courts dispensed with these suits, the elections held and were judged by many observers to be largely fair and credible, a development that led to the decision of former President Goodluck Jonathan to concede defeat to his challenger. And for the first time since the return of democracy, there was no petition filed to challenge the presidential elections. This, however, did not stop other candidates at other levels of the elections from challenging their losses at the tribunals. In anticipation of the election petitions, Justice Mohammed in February swore in 242 judges who were selected to serve on election tribunals. The tribunals have since concluded their jobs, and the legal battles have shifted to the Court of Appeal and the Supreme Court, which is the terminal point for governorship election petitions.
They have conducted their jobs within time, and that's very good. It's the idea of an election petition lasting 3 years into the term of the incumbent governor who may be deposed later has not arisen. I give that to these tribunals.
Most of the judgments that we have seen been judgments that are actually in compliance with the provision of the Electoral Act. We have also seen judgments where there is need for you to also question the rationales of some of those judgments. However, largely, I think nearly over 70% of the judgments that I've seen so far have been in accordance with the law.
One good thing that has happened to the judiciary this year is the passage and signing into law of the new Administration of Criminal Justice Act 2015. The Act, which is operational in the courts of the Federal Capital Territory and other federal courts in Nigeria, is to ensure that the system of administration of criminal justice in Nigeria promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crime, and protection of the rights and interests of the suspects, the defendant, and the victim. This new law would be well tested in the new year, especially with the corruption cases pending before the various courts.
Lawyers, defense lawyers, seem to raise objections, seem to want to take long adjournments on the pretext that they have so many other cases they're appearing on, pretend that they're traveling for medicals, and the pretext that even the accused will be traveling for medical. That's why you see most of these high-profile corruption cases, they don't finish, they don't come to an end.
No corruption case was concluded by the courts in 2015. The disputes between the executive and the legislative over the amendment to the Constitution was also not resolved. Also pending is a dispute between the federal and the state governments over value-added tax and the Sovereign Wealth Fund. 2016 brings with it the expectation that these issues will be resolved. Other cases which the courts must decide in the new year include the issues surrounding the Kogi state elections, the Saraki and the Code of Conduct Tribunal suits, the new corruption cases initiated by the Buhari administration, among many others. Shola Sheyeli, Channels Television News.